chair lays out House Bill 873 and recognizes its author, Chairman Collier, to explain the bill.
Chairman, members, thank you so much for the opportunity to lay out House Bill 873. I have a committee substitute.
All right. The chair lays out the committee substitute, the House Bill 873, and recognizes Chair Collier to explain the bill.
Thank you so much. You know, during the most recent winter storm, I was shocked and saddened by the number of reports of dogs dying as a result of being left outside, unattended, tied up, and without adequate shelter. Current law regarding the welfare and safety of animals outdoors is insufficient. The committee substitute to House Bill 873 is the result of years of consultation from various animal control officers, law enforcement agencies, prosecutors, and animal advocates. It's an attempt to provide guidance on how to safely and humanely tether a pet to offer adequate shelter. This bill is designed to provide clarity for pet owners regarding the definition of adequate shelter. It sets basic standards for dog tethering, provides additional guidance when pursuing charges, as well as increasing the penalty for repeat offenders. There is language to define adequate shelter. The ambiguity surrounding what constitutes a heavy chain is eliminated, and the mandatory 24-hour waiting period to allow law enforcement the ability to address critical and dangerous situations is removed and allows immediate response to take place. Now, there are 9 circumstances in which the provisions of this bill would not apply, and thus charges would not be filed. They include the use of a restraint on the dog in a public camping or recreational area, the use of a restraint on the dog while the owner and dog engage or actively train for an activity conducted under a valid license issued by the state, provided that the activity is associated with the use or presence of a dog, the use of a restraint while the owner and dog engage in the business of shepherding or herding cattle or livestock, the use of restraint while the owner and dog engage in the business of cultivating agricultural products, an unintended dog secured in an open-air truck bed for the time necessary to complete a temporary task, as opposed to permanently, the use of a restraint when the owner or another person with the owner's permission takes the dog from the owner's residence or property and restrains the dog for the time necessary to engage in an activity that requires the dog to be temporarily restrained, the use of restraint when engaged or actively training for hunting or field training, a restraint attached to a trolley system that allows the dog the freedom to move along a line greater than that of either 10 feet or 5 feet times the length of the dog, and a person walking a dog with a handheld leash. Again, this bill would not apply in those situations. There would be an exception to allowing that to happen. A first-time offense of this proposal would still be a Class C misdemeanor as it is right now, but a repeat violation would be classified as a Class B. Finally, the committee substitute makes one change of phrasing that does not change the intent of the bill. The substitute changes page 3, line 13 to read, Section 821.102 does not apply to, rather than it's an exception. This is a non-substantive change and only impacts the phrasing. We do have some really good witnesses here to testify about the impact of this bill. And with that, I'll entertain any questions and reserve the right to close.
Members, are there any questions for Chair Collier? All right. At this time, the chair calls Shannon Edmonds. All right. So can we change this to move on and call him back shortly, right? All right, let's move, now moving on to, yes, Shannon, did that move up? Yes, Shannon Sims. Yes.
Good afternoon, members of the committee. My name is Shannon Sims. I'm representing the City of San Antonio's Animal Care Services, and I'm in support of the bill. My background is I was a retired Marine of 22 years, and about 8 years ago, I got into animal welfare with the City of San Antonio. During my time there, I've been the field operations manager, the chief field operations officer, assistant director, and I'm currently serving as the interim director. The enforcement side is pretty much what I've always put my hat on. Focus of my testimony is going to really kind of be on the aspect of the bill associated with tethering, banning of chain. Similar bills have been presented in the past, two of which I've actually testified on. Upon its failure to pass in 2017, City of San Antonio actually moved forward and we decided that we were going to pass a law that basically reflects what this bill is. By using that at the municipal level, we decided that we were going to go ahead and implement it and see how it worked at that level. We're the 7th largest city in the nation, and my animal care officers write about 13,000 to 14,000 citations every single year. In the past 3 years that we've had this ordinance in place, we've written a whopping 370 Class C misdemeanors of a bill of, for violations of this type. That's out of 13,000 to 14,000 citations. Obviously, this bill, as previously outlined, does allow for a Class B misdemeanor. That's in the most heinous cases. Inability to educate and address things because there's not a law in the books often results in the death of an animal, could lead to a felony case. Folks that you're going to listen to after me, all of us in animal welfare, we'd really rather educate, utilizing a law that's on the books, have the ability to educate, cite if absolutely necessary, then file criminal and felony cases. Laws are not just a punitive tool. Folks are going to talk to you about, we're going to go out and we're going to be citing everybody that tethers, and it's going to be heavy-handed. It's not just a punitive tool, it's an educational tool. It does give us the ability, though, to not only educate by a law in the book, but also to move forward with follow-up, follow-through. We talked about the 24-hour requirement right now. Makes this current law unenforceable. So the current law also does nothing to allow us to educate and regulate what responsible tethering looks like. I actually wanted to take a quick opportunity to show you. This is what tethering responsibly looks like. Heavy, 250-pound tensile strength, swivels, doesn't twist. This is what we see. This actually came off of about a 50-pound dog, a little under a year old. For those of you, it does look heavy, doesn't smell real pleasant. On top of that, I've been actually carrying that around for about the last 4 hours here today, 4 or 5 hours. I'm worn out by it. I'm 185 pounds. Fortunately, that dog lived in San Antonio, lived in a jurisdiction where I can regulate that. You're going to talk to people that live in counties, places where they can't put municipal ordinances in. Those animals are doomed to stay on the end of a leash. Think back about 3 weeks ago, we had the freezing temperatures. I had county officers calling me, asking me, Shannon, what can I do? What can I do to get these dogs off of these tethers freezing to death? Unfortunately, my response had to be, there's nothing in state law right now. As it's written, that animal stays on the chain and it stays in the cold. So I would just like to please ask, this isn't a political issue. This is a common sense issue. This is a humane issue. as we move forward, thinking about the way that we regulate our animals, we're not looking to take away the ability to regulate in independent municipalities and smaller jurisdictions. What we are looking for is the ability to make sure that these animals don't die on the end of a heavy chain like the one that I just showed you. That concludes my testimony. If you have any questions.
Members, any questions for this witness?
Thank you so much for being here, Mr. Sims. Officer
ma'am.
Sims?
Yeah.
Is that correct?
Yes, ma'am.
Okay. Officer Sims, currently, that was a very big chain. I'm curious to know if your prosecutor's office has been prosecuting people under any animal cruelty statutes currently in place.
So we
that
do.
Seems like it would meet the.
Yes, ma'am. Yes, ma'am. We absolutely do felony statutes associated with Texas Penal Code. Having this law in place allows us to actually approach the individual, allow them to educate them and say, hey, this is illegal. It just doesn't make great sense. And then as like I said, out of all the citations that we do and 100,000 calls for service annually, in 3 years, we've written less than 400 Class C misdemeanors on this. So having that ability to educate and the threat of potentially receiving a Class C misdemeanor has been very successful in keeping us from having to move towards felony prosecution.
Okay. And then I just have one other question, because I don't know that there's ever an explanation for putting something like that around a dog, for sure.
Yes,
I am curious to know, I have a concern about a potential unintended consequence as it relates to homeless people. Okay, it's fine now. Unintended consequence as it relates to homeless people.
Yes, ma'am.
I don't know what the homeless population looks like in San Antonio, but if you've been around Austin just a little bit, you know that that's a serious issue. And even when we had the storm, there was a huge issue with homeless people not being able to get into certain shelters.
Yes, ma'am.
Because of their pets. And so there's a number of them, and this specific bill goes into defining what is adequate shelter, and it talks about water and shade from direct sunlight and things like that. And so it makes me nervous, this idea of citing potentially homeless people that they don't have a home. So their dogs
Yes,
most
ma'am.
likely will not have a shelter either. And, for those that are trying to consistently just kind of throw homeless people somewhere other than out of public sight, I'm just concerned about how this potentially may be applied. Do you have any opinions about the homeless population and kind of?
Absolutely, ma'am.
Okay, perfect.
So what I can tell you from San Antonio does have a fairly extensive homeless population. What I can tell you is the vast majority of homeless individuals that we've dealt with that have dogs, unfortunately, take better care of their animals than a lot of folks that actually have homes. They keep the animals with them. From a chaining perspective, the chain just isn't really practical. Obviously, they're going to have a smaller leash, tether, things like that. And just from their situation alone, they are going to the dog is going to be in close proximity to them at all times. What we see is, as they seek shelter from, basically all we're asking in this bill is to provide the same types of food, water, shelter that those very same homeless people would be looking for and seeking out. I've never really seen a homeless person where they're out of the sun in the shade and the animal was in the sun, where they had water and the animal did not. Again, I think that it speaks to, we're asking for the same basic types of shelter for the animal that the homeless person would be seeking.
Thank you.
Yes, ma'am.
Yes, Representative Johnson.
Thank you very much, Mr. Chairman. Thank you very much. I want to talk to you about animal cruelty or dog fighting cases.
Okay.
Would you explain to the committee how dog fighting rings usually hold their animals in their property?
Yes, ma'am. A lot of times what we find is the animals are staked out in fairly close proximity, but just far enough away from each other to not be able to get to each other. You'll see some type of cover and shelter for them. Typically, they're not on a chain much longer than the one that I've got here, about 10 feet. But you will see that type of heavy chain, that type of really a tow chain is what you're utilizing. From Animal Care Services, we've seen tons of big, strong, dogs. I've yet to find one of those animals that this wouldn't do the same job as that big, heavy tow chain.
And isn't
Part
it
of that
true that
chain,
usually the reason that they have that chain
it's
is they're-
basically a weightlifting program for the animal.
Correct. And it's a form of abuse to prepare the dog to engage in dog fighting by having them close enough that they're constantly engaged in going after the dog. So
Yes,
they're
ma'am.
Constantly strengthening. And so at this point, if you had a neighbor that called and said, hey, my neighbor's got 4 dogs staked up with a heavy chain just far enough, you couldn't do anything
There's
about
nothing
it, right?
you can do about it.
And that is probably a dog fighting ring, correct?
It's quite possible. It is one of the indications of that we would be looking for when seeking out a dog fighting ring. Yes, ma'am.
So acknowledging this provision would actually allow law enforcement to get in and prevent further harm to the animal that's visible to maybe neighbors who are out there seeing it, right?
Yes, ma'am. Like I said, I've been lugging this chain around with me for about 4 hours. My back hurts.
And in addition to that, for people who, let's say, are just not doing okay financially and think that a chain is cheaper,
This is probably about $25 at any place, and this is the heavy duty one.
right?
Chain like that is going to cost several dollars per foot.
And
So it's definitely it's more economical and it's more humane. This also doesn't tangle. It doesn't get the feces embedded in it. It's much more clean, sterile, and so there's also the health concerns from that perspective.
And we have a lot of groups who will help support people who want to be loving animal owners and are just on financial hard times. And they would also contribute or help support updating the kind of devices that are needed to properly tether for those who are struggling.
Yes, ma'am. I can't speak for every city, but I do know, like in San Antonio, the food bank provides these through a program called Daisy Cares. Animal Care Services provides these for free. Usually there's quite a few programs within each municipality or each jurisdiction that would provide something similar.
And with all the exceptions that we see in the bill around livestock and other working dogs, clearly what we're recognizing here, those that are having trouble, we can help out. Those that are potentially criminal offenders, we're just giving you a little bit of an avenue to try to get them in compliance and identify a bigger problem, right?
Yes, ma'am. Having something on the books that we can not only educate from, hey, what's the best thing to do as an animal owner, but this is illegal. Having that ability to say that to someone typically gets folks, most of the folks, in line. We had thousands of chain calls, but again, I've only had to issue less than 400 citations in the last 3 years.
Thank you.
Yes, ma'am.
All right, members, any other questions for this witness? Hearing none.
Thank you, sir.
Officer Sims, thank you. This time, Chair calls Mr. Shannon Edwards. Apologize for the confusion earlier, Mr. Edmonds. A couple of Shannons in the audience and witnessing today. So,
Thank you, Mr. Chairman and members. My name is Shannon Edmonds with the Texas District and County Attorneys Association. I challenge you to have another hearing where you have 2 male Shannons testify back to back.
that's it. If you'll speak on who you're testifying on behalf of, your position on the bill, please, sir.
Thank you. With the Texas District and County Attorneys Association, just testifying on the bill as a resource. This is one of the issues where we mentioned at the organizational hearing when there's a technical issue that may need to be cleaned up. We wanted to bring it to the committee's attention. Already sent some language to Chair Collier's office to make this bill track the way the bill last session got over to out of the Senate and over to the House, having to do with the difference between an exception, a defense, and an affirmative defense in a criminal case. And I can go as deep into that nitty-gritty law detail as you want, but the one sentence explanation is exceptions can sometimes make cases unprosecutable because they require the state to allege in an information or indictment and prove a negative at trial, which may not even have anything to do with the case. And if you just change, instead of saying it's an exception to the application of this section, to say this section does not apply to the exact same circumstances, then it doesn't come up in every case. But if the facts of the case do raise it, the burden is still on the prosecutor to disprove it beyond a reasonable doubt. So it gets the defendant what the defendant needs, but it doesn't create technicalities where some defendant may get, where the state may not be able to make its case because of something totally unrelated to the facts of this particular defendant. So it comes up a lot in drafting, and so this is just an instance where if that language starting on page 3, if it's just changed to say this section doesn't apply to all of those same 7 categories, it should work fine in practice should this bill pass and one of those cases ever get into a court. I'm happy to answer any questions on that.
Thank you, Mr. Edmonds. Members, any questions for this witness? Chairman Murray?
Mr. Edmonds, just a quick question. You've reviewed the bill language. Would you just explain what preempt? It says it does not preempt a local regulation, and how would prosecutors handle that? So just clarify what preemption would mean. County versus city. Who could actually do that? So I assume that's a municipal regulation that we're talking about, and then who would be prosecuting that?
Sure. In most cases, counties don't have the power to adopt those kinds of ordinances. Cities may, and an example might be our texting statutes while driving. We used to have you couldn't use a wireless communication device. We had a little patchwork quilt of different things all over the state, and you all decided in your wisdom to kind of impose more of a one-size-fits-all solution for them, and that's called preemption at the state level, where state law limits what the local municipalities can do. This bill would appear to specify that it does not preempt a local community like perhaps San Antonio from having their own ordinance, so they could maybe still have theirs and this one, and they could exist together if it meets the terms of this passage on page 4 of the filed bill. I'm talking off the filed bill. Was there a committee substitute? Yeah, there is. I'm sorry. But yeah, I haven't referenced the page number for that. But that's how I believe it would work in practice.
Thank you.
Representative Johnson?
Thank you very much. Mr. Edmonds, I wanted to talk a little bit about this connection around animal cruelty and where we may see other types of activity. For example, in a dogfighting ring where you may have a compound where they are breeding and raising up dogs to fight in underground illegal activity, a lot of times there may be other criminal activity that's occurring in that circumstance, like drug possession or delivery or anything of that sort, correct?
Correct.
And in this case, like we think of expanding our ability to protect citizens in Texas, animal cruelty is oftentimes tied to other forms of abuse as well, correct?
Both animal abuse and abuse against people.
Yes. And so there's usually a correlation that when we find a location of which we need to protect a dog, a lot of times there may be child or wife or other person in that place that also is being subject to abuse. Correct?
Correct.
Okay.
Yes.
So in the same way that on a traffic stop, it may be a legitimate Class C traffic violation that allows an officer the opportunity to put eyes on a human trafficking victim in a car and make a recovery. In this circumstance, a Class C offense to recognize signs of animal abuse may likewise allow law enforcement the opportunity to observe any other conduct that is illegally going on the premises, correct?
That is right.
And that would be a better thing for the security of all Texans in general.
That's for y'all to decide.
All right, I like it. Thank you.
I'm going to be neutral.
All right, thank you, Shannon.
Thank you.
Any other questions? Yes, ma'am, Representative Crockett.
Mr. Edmonds, hi.
Good afternoon.
Okay, so the questions that I have surround the fact that we currently have animal cruelty that's on the books under 42.092. And we have the illustration of the chain, which to me would just qualify flat out as animal cruelty. You work with a lot of prosecutors. Do you feel as if prosecutors have had an opportunity to currently, under our current laws, actually be able to prosecute someone if they say are tethering a dog with something that's as massive as what we saw, that chain?
As you know, what an officer can or can't do at the scene is going to depend on the facts that are before him or her. And so if there are law enforcement or prosecutors supporting this bill, I think it's because they see a need or a loophole there where they're not able to adequately address the conduct that is currently occurring under the existing law.
Okay. So going to the actual language, and literally we've just had so many homeless people, so I just want to be clear. I don't know if you have a copy of the committee sub in front of you.
I don't, but I can wing it.
All right, so under 821.102, it specifically goes through a long list in section A, saying that an owner may not leave a dog outside and unattended by use of a restraint unless the owner provides the dog access to adequate shelter, an area that allows the dog to avoid standing water, shade from direct sunlight, and portable water. So all four of those requisites have to be met first, correct?
Correct. It requires all four.
And then the next portion of that, B, it says an owner may not restrain a dog outside and unattended by use of restraint that is, and then there's a long list, and those are all ors. But one is a chain, weights attached, which obviously that's kind of common sense that that's bad stuff. There's one that talks about the length being shorter than, is shorter in length than the greater of 5 times the length of the dog as measured, or 10 feet. And it kind of goes through this, and so I'm just curious to know, because I don't want dogs tethered in an irresponsible way. I also don't want this particular section to be misused against people that are homeless. And so I guess you've had an opportunity to review this bill, and based upon your review, do you see the potential for a loophole for those that are homeless and maybe don't have access to certain things, or not? I'm just trying to see in your review, do you see the potential for a loophole?
You know, that's difficult to say because I'm not out there running into these situations. I think of, just based on my own personal experience, you know, somebody at a street corner here in town, plenty of them, panhandling, and they frequently have dogs with them, but they're with their dog. So all I can say is my personal experience. I can't remember ever seeing a dog by itself tethered in that type of circumstance. I'll be honest, I looked at this because I have a tether for my dog out front that we use because we have a fenced backyard but not a front yard, and with all the deliveries going on during the pandemic and everything, we can't have the dog out front. He goes after the UPS guy. Right? He's going to lick him to death, but they don't know that. So we have one so the dog can be out there with the kids playing in the front yard and everything, but we don't ever leave our dog out there alone. So, you know, all I can do is give you my opinion based on my personal experience, where I haven't seen that.
Okay.
But it's possible that other people have had a different experience.
Okay. Nothing further.
Representative Casey.
Hi, Mr. Edmonds. Who makes the determination of what adequate shelter is?
Well, ultimately, depending on how far the case goes, it could be a judge or jury. Initially, it would be the officer who is making the decision at the scene whether or not to cite or charge the person, the dog owner.
So it's really a subjective call based on the authority involved.
Based on, I mean, it should be based on the definitions that are provided in the statute, but yeah, officers don't have to, they don't have to have proof beyond a reasonable doubt at the scene in order to charge someone. They just need probable cause to believe that the statute has been violated. And that is what triggers the process of getting it into the courts, where then the burden increases and the decider changes.
Okay. Are there very many people that get caught up in this sort of thing? And I should have asked Officer Sims, but of the 300 and some people that were cited, you know, I was sitting here thinking, well, how many of those were actually guilty? You know, I'm just wondering if there's areas where people can get caught up in this where they're really not guilty, or they've not really violated or abused their animals. Is that a possibility?
I mean, that's always a possibility, and I can't volunteer San Antonio, but they may have data that you could ask for. Maybe if you wanted to circle back with them later, they might be able to tell you the outcome of those cases. I just don't have any way to know that.
Yeah, I mean, I see other things in here where the dog allows the dog to avoid standing water. I used to have a dog. It was an Irish setter, and yeah, if it could find water, it would lay in it. It literally would lay in it. The sprinklers in the yard, the driveway. Yeah. Okay, that's all I've got. Thank you.
Any other questions for this witness? Yes, sir. Sue?
Just had a few questions about what this bill does and doesn't do. So, run through a few hypotheticals with you, if you don't mind, just based off of this draft language. If you leave a dog out on a balcony of an apartment complex, and the dog, is out there for 30 minutes but doesn't have a water bowl, would that act in and of itself constitute a violation of this statute?
Just going off the committee substitute that I was just given, I think that may not trigger this statute because the dog isn't subject to a restraint.
Exactly. Okay. I had expressed some concern with me. Does this mean that people are going to be calling the police, every time they see a dog outside, that's unattended, but really what this does is it only applies to the use of a restraint on a dog. So that's what 821.102 has as the major qualifier, is the use of restraint, right?
Correct.
I had, and these are based off of emails that I've gotten from random people. And so I'm like scratching my head sometimes on some of these hypotheticals. I just want to straight up ask you, if you're training a dog for the Iditarod, and you use kind of like a chain on that dog to develop muscle mass, to have resistance. I'm not sure why they would be using the chain for that purpose, but does something like that, does that fit in with the exception when we talk about a valid license issued by the state? I'm a little confused about what that exception extends to.
Well, and I guess my first question would be, is the dog unattended? Are they working out on their own?
I think they are attended. That would be my understanding.
And so
working a dog out for
right, so if you're working your dog out in whatever you're doing, and you're there, and the dog is tethered, I understand that to be okay. I hope so, because that's what I just admitted to,
No,
right?
and I think you're right in the sense the statute goes for restraints and unattended.
Correct.
So another example, if you're driving around, my grandfather used to do this all the time. If you're driving around, you've got your trusty dog in the back of the truck, and you're just driving around. That dog is technically not unattended, right? Would
I
that
would
be
ag-
your reading of this?
Yes.
So by unattended, it means that you're actually not even. Does unattended mean that you may be on the property but not outside, or does unattended mean you are not at the property?
So it doesn't appear that the bill defines that term,
Okay.
which means the courts are just going to look in the dictionary to determine what the definition of attended or unattended is.
Trying to remember one of the other weird hypotheticals that was given to me. I just want to ask, just to clarify, so dogfighting is illegal in Texas, right? I mean,
We have a separate dogfighting offense in the penal code in addition to cruelty to non-livestock animals.
the one other question I have, when it talks about a collar, it mentions it does not cause pain or injury to the dog. Do you read that to mean pain or injury to the dog in the ordinary course just from the presence of a collar? Or because, for example, if you're walking a dog on a leash and you may pull that dog back, or if you're a small person with a big dog, maybe the dog pulls you, that process may cause theoretical pain to the dog. I'm trying to understand what we mean. Is it pain just from the mere presence of a collar, or is it pain in the use of a collar?
And so the causes pain or injury to the dog seems to be in regards to the outside use, unattended outside use of a restraint, which means a chain, rope, tether, leash, cable, or other device that attaches a dog to a stationary object or trolley system. So I'm not even sure it would get into the details of the collar, and this is Augie.
Mm-hmm.
Augie's got a prong collar when we go for a walk because if there's a squirrel, Augie's going after it.
Mhm.
And so I don't think, and obviously that's one way that it controls.
Right. Because I think under
Dog.
the current law, and correct me if I'm wrong, wasn't it that a properly fitted collar included one that had an inch of breathing room right on it? I think was what the current definition had. Which,
No, I'm gonna plead ignorance on that one.
no worries. That's what I thought, and so that's where I was kind of getting at. I guess my understanding of this provision is it's a collar that causes pain in its ordinary use, like it's too tight, or it's got something on it that's irritating the dog.
And keep in mind also, the officer is going to have to see that the dog is in pain,
Right.
right? So so something that might be accidental, or even if it looks not good, but the dog is tolerating it fine, then there's no probable cause to believe the dog's in pain or being caused pain by that collar.
Got it. That's all I had so far. Thank you very much.
Representative Casey.
Can the officer use this statute as a reason to invite themselves onto a person's property?
So if an officer sees through plain view what he believes to be the commission of an offense, then he can probably do that. I would say that for a Class C misdemeanor, he would be limited in his ability to go inside the home. But if it's on someone's yard, that's possible, especially if there's no fence or no trespassing.
What if it's
Find
in
out.
the backyard and it's a wooden fence?
Yes, well, so he wouldn't, if I'm thinking of my own privacy fence, you can't see through it, so there wouldn't be.
What if a nosy neighbor called him?
That's redundant, right? You know, there's a variety of ways that an officer could pursue that, and probably Officer Sims might be better able to answer how they would handle that specifically. But there are, we talk about terms like the curtilage of a house and other things protecting a home that are more restrictive than an open area of a yard or a carport that's not enclosed or things like that. So it really depends on the facts of the property itself.
Okay, thank you.
Representative Johnson.
And Shannon, since we've kind of gotten into the concept of dogfighting, usually what declares the winner of the dogfight?
Whichever one's still alive.
Yeah. So if it gets to that point, the preventive measure, if we do have somebody, which we do, because this happens all the time, and this can be a mechanism by which you can protect the dog before it's killed in illegal dogfighting, right?
Yeah, that certainly could be a use.
Yeah, thank you.
You know, the question, I've got one, just to go back to a previous question. A dog, and number 6, a dog taken by the owner or another person with the owner's permission from the owner's residence or property and restrained by the owner of that person for no longer than the time necessary for the owner to engage in the activity that requires the dog to be temporarily restrained. Is that the ability for us to carry working dogs, cattle dogs in the back of our pickups from point A to point B? Is that, I just want to make sure I've got that. I've got those dogs. I got a lot of friends that got those dogs, and I remember last session, we specifically discussed that matter as far as about cattle dogs and dogs in the back of a truck and putting a tether on them to keep them from jumping out of that truck. So I just want to make sure we're crystal clear. Those are allowable under this.
I'm not privy to the intent behind it, but it looks like both Section 5 and 6 would cover that type of transportation situation if there was a restraint.
Mr. Vice Chair, just to comment on your question, though, if you review the end of the language, the preemption statute there, my only observation might be that a local authority that has the ability to create that, they could make a more stringent rule or regulation and take out some or all of those exceptions, I think. And I haven't heard anybody tell me any different. So counties don't have that authority, but municipalities would. So in theory, a municipality could remove the very exception you're talking about.
Right. Thank you. Appreciate that, Chairman. Any other? Yes, Representative Olson.
But a municipality could already enact an ordinance that says this very thing without those exceptions.
Correct.
This bill doesn't, one way or another, affect the municipality's ability to do that. Is that correct?
Yes, a municipality could have their own ordinance with a separate punishment. It could not remove the defense from this law if it passed, but they could create their own, and it could have varying levels of defenses or exemptions.
Thank you.
Any other questions for this witness? All right.
All right, thank you.
Thank you, Shannon. Moving on, Chair calls Mr. Jamie Cantrell. If you'd please state your name, who you're testifying on behalf of, and your position on the bill, please.
My name is Jamie Cantrell. I am the president of the Texas Animal Control Association, and I am also the Animal Services Director for the City of Plano. And I have been in animal welfare for over 25 years now. And I've served in every capacity possible in a shelter, from kennel attendant to director. And I had prepared a written statement today to read to all of y'all, but kind of going off script a little bit, and we'll just be talking from the hip here with everything. So to answer some of the questions that you've been having, no animal shelter in Texas wants to take any loved animal away from its owner. Doesn't matter if they're homeless, doesn't matter if they live in a mansion. If they're taken care of, we want them to stay with their owners because that's what they know, that's what they're happy with. Dogs, really, that's all they care about is if they're loved and provided for the people that own them, then they're going to be happy. So we try to help people be more responsible pet owners. And what this bill does is provide a blueprint to be a more responsible pet owner when it comes to tethering. So even if there were an issue with a homeless person, they have the same rights as any other person does in the country. We can't just go take their dog away because they're homeless. We would have to have a civil seizure hearing and provide evidence on why that animal is being abused and why it needs to be taken away from them. Okay? So if we lack that because they take care of their dog, then there's no reason for us to even try to do that. We, again, just want to help them be a better pet owner by giving them medical care, giving them vet care, that type of stuff, so that they can be better owners for them. Representative Kaysen, you asked about the adequate shelter. Currently, there is no definition of adequate shelter. So some people argue that that tree that the dog is under is adequate shelter. Doesn't matter if it doesn't protect them from the rain that's coming down or the snow that they're in. They have adequate shelter because there's a tree that they're next to. And that's what this bill does as well. It gives a definition for adequate shelter so that everyone has the same standards to go by. And it's not just up to, what I may think is adequate shelter, you may think is adequate shelter. It's what Texas has decided is adequate shelter. Also, the police department normally doesn't investigate animal calls. It is, in most cases, going to be an animal control officer. They're in very small jurisdictions. They may not have an animal control officer, and their police department may handle those things. But it's those small jurisdictions that actually need this most because it helps them go out because they don't have the understanding and the expertise and the experience that we do to go out and deal with those cases on a regular basis. Because that's all we do. For them, this is just kind of a side thing of, well, I'm also having to deal with everything else that's going on in the city. Animal calls typically are a lower priority for them. We also don't care if your dog plays in standing water. My dog does that too, other than it makes them stink all the time. So I know what you're dealing with in that one. If you are training dogs for the Iditarod, you're in the wrong state. I'll tell you that. I'm sure you did. Trust me, you would not believe the emails that I get, so I can only imagine the ones you get. But regardless, this only applies to unattended dogs. So if you're right there with your dog, we have that all the time. There's, the little old lady likes to go out and do gardening, and she wants to chain her dog to the tree while she's up there, so it's out there with her. That's fine. In Plano, that's one of the acceptable means of tethering. We don't allow any sort of unattended tethering for any period of time, and that's what we've done as a city because we feel like that's what our standard is. But if they're out there with them, then that's fine for them to be there like that. Whenever it talks about having a collar that causes pain, what we're talking about are those pinch collars, the training collars. If you're walking your dog, you can kind of control your dog a little bit to where they're not going to just sit there and pull and pull and pull to where they hurt themselves. If they're on the end of a chain, especially if it's one of those big chains like what you saw earlier, that's constant pressure. That's constant pinching. They can't get away from it no matter what they do. So that's what we're trying to stop with this bill as well. And also, Ms. Johnson, there's two ways that actually you can win a dog fight. One is your dog is dead, or lose a dog fight, excuse me. The other is if your dog fails to attack the other dog. They have rules. They'll put them on lines, and if your dog is the aggressor in that situation, they say it's your turn to go, and your dog doesn't run across and attack, your dog's disqualified. You lose. Unfortunately, if you lose a fight like that, you're probably not going to be kept alive much longer because you're no good to them. If you're not going to continue to fight, regardless of how tired you are, how injured you are, you're just no longer of value at that point. And then also, you're correct. Dogs in the back of pickup would be allowed by this. It's not something that is prohibited. And actually, I would much prefer to see a dog be restrained to the back of a vehicle in some way as opposed to just running free and bounce around because you get a wreck, an accident, or hit a sudden pothole and the dog isn't tied down some way or restrained in some way. It's real easy for them to fall out and get really hurt. So it's preferable in those situations. So our only thing that we want to do when we go out and investigate complaints is gain compliance. Education is our first tool. That's what we want to do. If we can educate an individual and they say, yes, I will be a better pet owner from this point forward, we're happy. We're going to go on about our business. We'll go to the next call. Okay? We're not peace officers. We don't have the ability to go in and arrest you if you don't do what you're supposed to do. We just can go in and try to help. And so that's our first line of offense, basically, when we get there, is what can we do to help this situation, because it helps the animals. That's what our primary focus is. This is the only situation that you can find in any law in Texas where you're required to give a 24-hour notice before you can do any sort of citing or any sort of enforcement action. And it's also, this bill also gives us that much-needed definition for shelter that we've talked about. It helps clear up a lot of the inconsistencies and problems that we have with current state law. And if nothing else, the weather that we had recently showed us why we need a bill like this. So with that, if there's any questions, I'll be happy to try to answer those as well.
Before we start that, Mr. Cantrell, will you let me know, the committee, whether you're testifying on, for, or against?
Oh, I apologize for that. I am for this bill.
You got it. All right. Members, any questions for this witness? Yes, ma'am. Representative also.
Thank you. So currently in Plano, or your experience with local ordinances, how do you determine what is a properly fitted harness or appropriately sized? And I ask this just because, you know, we always want to look for objective ways to define conduct that is in violation of law. And so I'm wondering if there might be a way to, is it like you can put a finger through it, or how do you all gauge that right now?
Well, the reason we have so many issues with stuff like that is because there's so much gray area when it comes to this, because it depends on what kind of collar they're wearing. There are certain collars that are designed to kind of tighten up as they pull or pull out of it. The reason for that is because you have some dogs that are very thick neck, but then their head's kind of like a bulldog. You know, they have thick neck, so if it fits around their neck kind of loose, then it just pops right off their head. And that doesn't do you a whole lot of good when you're walking your dog, if they can just pull out immediately. So there's special collars and things like that that you can get that kind of make sure that that doesn't happen. What we look for in our ordinances is that it is basically tight enough to prevent them, if they were to be tethering, well, that's what we're talking about here today, it would be tight enough to where they can't just pull out of it. But at the same time, it's not so tight that it's going to cause any sort of injury, rubbing the hair off of their neck, hurting their skin, that type of thing. So you will see with animals that are, dogs especially, that are on collars that are too tight, you start to see it, especially underneath on their neck, it starts to rub raw. I have seen, and everybody else that works in animal shelters, we've all seen the collars that were put on like when they were puppies, and then they grow up and no one ever changed their collar out. And what happens is that the body grows around the collar, and the collar doesn't get any bigger. It can't stretch. So you literally will have to go in there and sometimes cut the skin to be able to get the collar out from underneath, because it's grown into it. If they have a choke chain type of collar, it's especially worse because all that skin grows through each one of those links in the chain. So you have to do major surgery in order to get those collars out of their neck. A lot of times it's horrendous. So, you know, but sometimes it's really difficult to come up with, you know, one set standard or one set definition. But I think in this case, we have a much better bill that we're discussing today than what we have as state law currently.
Members, yes, Ms. Representative Johnson.
And just to clarify, for those homeowners or those individuals that love dogs but are just struggling, you're going to provide them the resources to be able to get them educated or provide them the equipment that they need to usually meet these definitions, correct?
I can tell you, I've been, like I said, been doing this for over 25 years. I have never told somebody sorry when they ask for help. You know, it's not in our nature. You know, we're here. You don't get into animal welfare because you're going to get rich. You do it because you have a good heart. And, you know, that's what the people who do this job, that's what they want to do. And it's not just for animals. You know, we want to help people as well. Unfortunately, we sometimes see the worst in people, and that can kind of make you jaded. But, you know, at the same time, we also see some of the best in people as well. So anyone who has ever asked for help, we'll find a way to help them. Even if we can't provide it ourselves, we normally know who we can kind of steer them to get what help they need.
And in this circumstance, you have seen, and I'm sure you can describe and go through the detail about the abuse and what these animals go through. You have seen these extreme cases, and right now, without this law, you have to walk away and wait for the dog to suffer longer.
That is correct. And one of the things that everyone may not know is that whenever dogs live on the end of a chain that's just a fixed point, they basically are in isolation for their 24 hours a day, 7 days a week. It is mental torture. I mean, there's just no other way to describe it. So what this does is by giving them the ability to be able to use like a trolley system, the dogs feel like they are more free. They don't just have this one little, section of land that is theirs. And that's why they get so defensive of it as well. And that's why it's dangerous for kids to wander up to dogs that are chained, because those dogs, all they have is that little 10-inch or 10-foot round patch of dirt, basically, that they typically have. That's theirs. That's all that they have in the world. So they're going to defend that against any other animal that might come up there. They're going to defend it against any person, any kid that they don't know coming up in there. So it creates a very dangerous situation. And again, it's mental torture for those dogs. It drives them crazy after a while.
And this law would help you take earlier interventions.
That is correct. We can make it to where they wouldn't get to that point to begin with.
Thank you.
Anyone else? All right. Thank you, Mr. Cantrell, for your
Thank you.
testimony. At this time, the chair would recognize Mr. Art Munoz. Mr. Munoz, if you would state your name, who you're testifying on behalf of, and your position on the bill.
My name is Art Munoz. I'm the director for City of Garland Animal Services, and I am for the bill. Good? Well, my colleagues, they provided great information.
Perfect.
Yeah, and I'd just like to add that I have over 17 years' experience, and I've been blessed to work it from an animal control side and from a law enforcement side. And a lot of the cases that I have filed have been in reference to dogs that are tethered inhumanely. And to answer your question, Representative Crockett, I actually was commissioned with the Dallas County DA's office, who actually have their own animal cruelty unit. And unfortunately, with the chains, we couldn't file those cases because it just didn't fit the criteria. So this right here is going to give us the ability to work that right away. And I'll give you guys an example. Just over the winter blast, we responded to 322 calls, with half of those calls being animal cruelty cases. We ended up seizing 6 dogs, and one of them was deceased due to starvation and hypothermia. So these are the cases. This is the bill that's going to help us prevent that from happening in the future.
Members, are there any questions for this witness? Representative Crockett?
Thank you. Thank you so much for being here. And I'm just going straight to the point. I absolutely disagree with big chains and heavy, like the abusive things, right? The things that lead to discovering these fighting rings. Section A of 821.102, Section A, and the way that I read it is you can be charged with unlawful restraint of a dog if it's A, or if it's, you can be charged under 102A or under 102B. 102B, just to me, is absolutely, you keep hitting this thing. So the way that I read it is you can either be charged under the statute under either Section A or Section B. Section B, I don't really have questions about. It's the Section A that makes me nervous, and the description of what you're given doesn't really fall necessarily under A. That's the one, what you're talking about is B, and I think the majority of what we've heard is under B. And it can be either or, is that correct? Either you can be charged under Section A or B?
Yes, from my understanding, yes.
And so Section A doesn't really address kind of the things that we've spent the majority of this hearing talking about, which is just, the inhumane level of this. But So because you've been in Dallas, my district is South Dallas.
Yeah.
I have probably the highest incidence of homelessness in my specific district, HD 100, right? And so, you know, this idea of piling up tickets on people because honestly, adequate shelter, while there is a definition, that freaks me out as well because a lot of the people in my district, they don't have adequate shelter, to be perfectly honest, right? And so I guess my question to you is, do you feel as if you would be able to do the things that you're really trying to get at if you just had Section B and didn't have Section A? Let me ask that.
Well, no, still because I like it. Right now, there's no definition for shelter, but this kind of helps with that. And I will say I've been called out to homeless people and animals, and we've never had an issue. We've always educated them or provided the resources they need. This here describes, adequate shelter, and then 2, allowing the dog to avoid standing water, shade from direct sunlight, and actually having potable water as well. I think those we're going to need. And I've worked many of cases in South Dallas. And now I'm in the city of Garland, and we don't have an ordinance. So our officers rely on this bill. And I think this is going to prevent a lot of issues moving forward. 1, preventing harm to the animal, and 2, having to write those citations or actually file a case rather than educational beginning.
Okay. Thank you.
Any other questions? All right. Thank you. If there's no more questions for this witness, we appreciate you for coming, Mr.
All right.
Munoz.
Thank you. Appreciate it.
This time the chair will call Mr. Sheriff Brian Hawthorne. Sheriff? You'll state your name, who you're testifying on behalf of, and your position on the bill, please, sir.
Chairman, thank you. I'm Brian Hawthorne. I'm the sheriff of Chambers County, Texas, and I'm proud to be there, and I'm proud to be here representing 253 other sheriffs for the Sheriff's Association of Texas. So with that being said, everybody preceding me has definitely told you just about everything you need to know. I'll definitely answer questions. It's important for me to let you all know, it's been said a couple of times, in the county world, we don't have the ability to have leash laws and other ordinances that they do in cities. So this is a tool for a sheriff or a county animal control service to have the ability to deal with these issues. These issues are daily. These issues sometimes can be hourly. And to give you an idea on what adequate shelter is, I can give you an example of when it was taking place a few weeks ago as the storm we all know about. Adequate shelter was whatever we felt it was. Let me give you an example. When the electricity wasn't working in the house wasn't much better shelter than the doghouse. So bottom line is for us, when we were enforcing that, if the dog had adequate shelter from the wind, the rain, the snow, had the ability to have warmth, those were things we consider adequate shelter. Because it obviously, especially in a scenario where somebody may have left their house because the power went off and then the dog was still left in the cold, it was very important to us that the dog did have shelter. If it didn't, then obviously we ended up providing him shelter. But to be quite honest with you, our animal shelter that the county has wouldn't probably be much better shelter than what he was in. So, but this is a very important bill for counties. Most of the people that have spoke before you are coming from within the city world, some of these animal control. These guys are experts, they know what they're talking about, and I can truly say they're trying to help the counties, they're trying to help the state of Texas prevent animal cruelty and things that can be prevented. So this is a good bill. Sheriff's Association endorses it. The one thing that is important to us is that it does have the protections for the herding animals. I'm a rural county, I have lots of cow dogs. I'm a duck hunter myself. I do field trials with my Labradors. All of those protections that are in there to help the hunters, the fishermen, the sporting people, the cattle people, they're all there. We feel it's a very good bill. This is not the first session we have supported this bill. We have supported this bill in past sessions when it got tied up for different reasons. So with that being said, I'll answer any questions, or I'll step down because I know it's been a long day for y'all.
Sheriff, would you just make it clear whether or not you're testifying on for or against the bill?
Definitely for the bill.
Great, thank you.
No, thank you, Chairman.
Any questions before the sheriff goes? Thank you, Sheriff.
All right.
Being
No,
here
thank
today.
y'all.
Appreciate you. At this time, the chair would call Robin Cates. And if you will state your name, who you're testifying on behalf of, and your position on the bill, please, ma'am.
Absolutely, Vice Chair. Vice Chair and committee members, my name is Robin Katz, and I am for the bill. And I hope that you will also be for the bill after the conclusion of this hearing. So I just wanted to give you, as everybody else did, a little bit of a background of where I come from. I spent over a decade as an attorney, as a prosecutor, currently a city attorney and city prosecutor. Prosecuted both felonies and misdemeanors out of both the rural county of Comal County down in New Braunfels, as well as Bexar County, so large city, San Antonio. Through those prosecutions, I handled cruelty matters, cruelty prosecutions. Through the city attorney position and city prosecution, I handle cases that would come to me that would be based on a law like this, because it's a Class C misdemeanor. It's not a jailable offense. I'm also a professor of law at St. Mary's University. I teach animal law, and I also teach at Texas State University in their master's program of legal studies. I wanted to address some of the questions that all of y'all had before that maybe I can sort of help answer if they weren't already sufficiently answered to your satisfaction. And then when I'm done kind of going back to those, if you have any other questions or you need to ask a question again that I forgot to answer, feel free to do so. So regarding the homeless question that has seemed to come up, I do want to point out two things. The first is that part of this bill requires us to prove ownership. And common sense, as one of the people who testified mentioned, tells us that, at least from the prosecutorial standpoint, that ownership is, well, in the bill, care, custody, or control, right? And so typically when we cite somebody for an offense of, or when law enforcement does or an ACO does for unlawful tethering, it would be, how would we prove ownership, right? Well, we prove ownership basically by where the dog is tied up. So if you're talking about somebody who's homeless, and we're talking about a dog that is restrained unlawfully, so with a heavy chain, with not adequate shelter, and there's nobody in sight, so they're unattended, how do we prove the ownership? So I don't think that citing folks who are homeless is going to be an issue in this case. I think that may fall under 42092 of the Penal Code with animal cruelty and with seizing animals, because we're not talking about seizing animals here. I just want to make sure that that's very clear. We're not talking about ACOs and our PD and SOs coming out to people's houses and saying, oh, there's a dog that's tied up wrong, I'm going to go and take it. That's a whole separate process under 821.021 of the Health and Safety Code. That's a civil seizure. They could use a criminal warrant as well, but civil seizure is usually the preferable method of removing the animal. So this is simply a citation, and but before it even gets to that point, it's typically a method of educating the people to let them know, look, we have these resources. You can choose to take these resources and fix the problem. If you don't, we at least have this option and the discretion to cite them. If it ends up being a potential cruelty situation, then they would still need to go through the civil seizure process. As far as can we just walk into somebody's I don't remember who asked that, walking into somebody's backyard, okay. So, Representative, you can't just go into somebody's backyard. If it's within plain view, as somebody else mentioned, then yes, and that would be in any criminal case. If it's in plain view, it's fair game. I mean, if they're going into somebody's house with a warrant and it's in plain view and they see heroin on the counter, that's another offense, right? But they can't go fishing around. Nosy neighbor. Now, if there's a nosy neighbor who reports a dog on a chain that they believe to be inadequate, tethering, or I'm sorry, inadequate shelter, unlawful restraint, then the officer, so there's two situations. One, if it's an emergency situation where the dog is literally dying, then there's always an emergency exception doctrine. That's, you guys, there's Pine v. State, which talks about that, and it does apply to animals. But there's time for that officer to go get a civil seizure warrant. I mean, in both in Comal County and in Bexar County, and in even my cities like, who I'm not here representing, let me just be very clear about that, Copperas Cove in Coryell County. We have our judges who are available at any time to sign a warrant if needed. So the officers have the time to get a warrant if it's that situation in the backyard. We are just talking about situations where they're in plain view.
Counselor, could I stop
Yes, sir.
you just for a second? Chair would like to recognize Representative Cook has joined the committee on the dais. Go ahead, Counselor.
Thank you. What else did I write down that y'all were wondering about? The preemption issue. So I know there was concern, can the cities, the municipalities make it stricter? Well, that's like most other laws that we have right now. As long as it's not preempted, the city can make a law that's stricter than what's on the books for state. And so I don't remember what the example was. The texting law, right? I would say the truck bed law, right? There are cities that can and will probably continue to make it illegal to have a dog in the back of your truck, and that's just how it is. And there's nothing we can do to fix that. But this also doesn't change that. It still gives local control, because the only people that really know what's going on in their community, because where you live, Vice Chair, is very different than Kerrville or Buda or Seguin or wherever. And so you make laws that are sufficient for your municipality. But this is just the bare minimum that counties, like other people who are testifying, mentioned. It would make it much easier for them to have a bare minimum law for them to be able to address as law enforcement and ACOs.
Well, anything else you'd like to add before we get to questions?
Ah.
I think that's...
No, Chair, I'll
Thank
ask the
you.
question first. And then she...
Yes.
Yeah. Thank you so much, Mr.
There you go.
Chairman. You just talked about the preemption portion. So the question, I believe, was whether a city or a local government can remove some of these exclusions for prosecution. So if this is the basic standards, can a city or a county make something less stringent?
So I can speak on behalf of the city. So can the city say, you know what, we're going to go ahead and let people use prong collars and choke collars and tether? No.
Okay. And so if they say that the exceptions, those exceptions that we have laid out, if a city doesn't want to have one of those exceptions, can they do that if this bill passes? If the city says, no, we want to prosecute people for having dogs like that.
So they want to be able to make one of the exceptions, or defenses, or
Right.
make those prosecutable.
Yes.
Yeah.
They would be able to remove these exceptions?
Well, they're not removing the exception.
Okay.
What they're doing, this is the state law.
Right.
What they would need to do is create a municipal ordinance that addresses just that.
Okay.
And so if somebody gets a ticket, so, I'm just going to pull out one of the exceptions, and I know that language is going to change. So, I'm sorry?
Back of the pickup's a good one.
Back of the pickup, yeah. There you go. So back of the pickup, if the city of San Marcos, which already has an ordinance addressing that, wants to keep that ordinance, then they get to keep that ordinance. If New Braunfels wants to pass an ordinance that addresses that, then they can pass that ordinance. But when the person is charged, they wouldn't be charged under 821.10, the 821 section, subchapter E. They would be charged under city ordinance X, Y, and Z.
No.
And it would be fine.
Right. But what if the city said, no, we want to go after those who keep their dog in the back of the pickup truck? Could they do
Right.
that? Yes.
Right.
Because of local control.
Correct.
All right.
And that's how most ordinances are drafted. They typically, they look at the state law and they think, okay, what does our community want? does our community want something stricter in our community? And if so, we address it through the local ordinance, as long as there's not preemption. I know, there's certain, like TABC, there's a lot of preemption there, but with this, there's not.
Any other questions? Yes, sir. Representative Casey?
What is potable water? Could it be, I mean, I know what it is, but could potable water be water from a hose?
Yes.
Okay.
Yes. So what we're talking, what this is addressing is water that is filled with green gunky algae and probably disease-borne.
Now be careful, because I've got dogs that have drank green gunky water.
Do they have diarrhea out in the next?
No, they were fine.
No? Okay. Mine have. I take them to the river. But I mean, honestly, as a prosecutor myself, I really, when I have calls, and I got calls from my PD officers all during the storm saying, what do I do about this dog that's chained up? And I'm racking my brain and scratching my head, and they want to help, but the problem is by the time I get the case, even if they cite them, it is so hard for me to prove each and every element. I think that the cleanup of this statute makes it much easier for, number one, ACOs to go out and educate, because it's more clear, and it's not all this confusing, between 10 a.m. or 10 p.m. and 6 a.m. and all other jargon. It's clear for the ADAs, if it ever gets up to them. Mainly it'll come to city attorneys and city prosecutors for us to be able to draft the charging instrument properly, so that if we need to take it to a bench trial or a jury trial, we can do that confidently.
Representative Johnson?
Thank you very much. And again, I know I'm piling on here, but this law allows for those dog owners who are just struggling to get the assistance and not be brought into prosecution and say misdemeanor court through a Class C, right?
Sure, yeah, I mean, it's every Class C is the discretion of law enforcement. I have people, coming in, stealing hand warmers, and law enforcement, some will charge them. And they're homeless, but they're just trying to stay warm. Do you charge them with a Class C misdemeanor because they stole $8 worth of hand warmers? Well, when you live in a community that pushes for that, then you do. When you live in a community that's more understanding, then you don't. And so it really is based on the community and what's acceptable there. But yes, I can't imagine, I mean, really ACOs, and like they were testifying, they don't make the money like attorneys make. Certainly big corporate attorneys. They do it because they love the animals and they want people to be in compliance. And all this does is allows for a tool for them to use in case these people, decide not to take the available resources and not to be in compliance. And to your point, as far as family violence and dog, absolutely. I talk about that all the time. I've gone, and there is a huge link. And when I teach law enforcement, and I do at Comal County Sheriff's Office, New Braunfels PD, Bear County, SCPD, when I did my trainings, the first thing I said is if you get called to a family violence case or even a drug case and you walk in and you see an animal in a anywhere, be observant, ask some questions. If you go to a family violence case and there's somebody where there's an animal, bring the victim aside and ask them about it. That's why animals are now included in protective orders, in case you didn't know. They are, which is awesome. So, sorry, tangent, but
No,
I'm on board with that.
That's okay. So this law, one, it gives you the discretion to help those that are struggling, but it also gives you the enhanceable ability to start addressing those animal abusers. And just like you said, and I'm sure the committee doesn't want to hear it, but if you've been in a position to prosecute a dog fighting case, it is the most gut-wrenching, grueling, painful experience to see the evidence of these compounds and the abuse that occurs on it. And this is a tool we don't currently have to prevent and allow you to intervene at an earlier point, correct?
Correct. Yes. Absolutely. You summed it up.
Representative Crockett?
Yes, thank you. So I'm curious to know, these resources, what section of this bill talks about the resources that are being given to those that don't have access?
So, so that would, I guess, fall under the discretion of the
Oh,
animal
okay.
control officer that responds.
Okay.
And there's not a requirement for the ACO to say, hey, here's a bunch of resources. But, you know, it would be the same as I mentioned, like a theft under 100. So you hope that you have responsible ACOs and law enforcement. The ones that I've interacted with have been fantastic in all of the counties and cities I've worked in. And for and a lot of them really do go out of their way, and they're also very well connected with the community efforts to make sure there are, you know, dog houses provided or fences provided so that people may not have to tether anymore. And so they're well connected, and they typically do provide those resources.
Let me ask you another question. You specifically talked about local control, and we heard from a number of persons that testified that their local municipalities have actually passed ordinances to kind of address some of this. Any city in the state of Texas could technically pass an ordinance if that city felt as if it fit the personality of that city and they wanted to do something on this issue. Isn't that correct?
I mean, technically the answer is yes, but there are, 254 counties in Texas?
And a lot more cities.
Yeah, right. But it's expensive. City attorneys are expensive to hire. There's a lot of other ordinances they need to be drafting, and as a city attorney, you're not just doing prosecution. I mean, that's, you know, a piece of the entire pie. I'm working on land use and real estate and leases and contracts and water issues and ERCOT issues now, you know, so so it's typically, you know, out there amidst a bunch of different issues that they need to deal with. At least this minimum, which is a common sense minimum, will be there so that if the cities choose to be more strict about it, then they can be. And to be quite honest, this new the bill is not so dramatically different than the last one. Really, it just cleans it up to allow the people who are going to be enforcing it, the ACOs and the prosecutors, to be able to do what it was designed for us to do. That's it.
And then my last question, and it goes back to this Section A, because once again, I don't have any
Sure.
issues whatsoever with Section B. There is a definition of restraint in this bill. Looks like number 6, and it basically says a chain, a rope, a tether, a leash, cable, things that we would consider to be a leash. I would imagine is okay under normal circumstances. So it's defining restraint, and so it seems like B goes into kind of those ugly restraints that we saw, the big chains and like that kind of thing, right? And it's I don't know if there are ways to kind of clean up maybe Section A. My only concern is that even if somebody has a proper restraint, right, it can be a regular leash. They can be charged if they don't have adequate shelter, which says here means a clean and sturdy structure that allows the dog. So first of all, it has to be a structure. And then under that, it says that it allows the dog protection from rain, hail, sleet, snow, and sub-freezing temperatures. And with dimensions that allow the dog while in the shelter to stand erect, sit, turn around, and lie down in normal position. These are all, I'm not saying a dog should not have access to that, right? I'm not saying that. The reality of the world that we live in is, sadly enough, there are people that don't have access to adequate shelter. And one thing that I specifically dealt with in the aftermath of the ERCOT blunder was trying to help homeless people in my district that literally could not go anywhere where they could actually take their dogs. Like, they weren't taking the animals. And so, I thank God I've never been on the streets and I've never been homeless, but I don't want to be deaf to that. And I am concerned about, as I've stated before, the unintended consequences, because as you've stated, it's up to the locals what they decide to do. And so, I don't know if there are any suggestions to where you know, because it almost feels like if you don't have a shelter for your dog, you better have your dog with you 24/7 because otherwise it could be a situation where somebody who is, say, homeless could be charged. And we already have, sadly enough, in my opinion, a criminal justice system that continues to put a heavier burden on those that we've heard from lots of indigent counsel today, right? And so I don't want to do anything, even though this is a very well-intentioned bill, and I agree with everything about it as far as taking care of our pets and animals. I want to make sure that we don't end up doing harm when we were trying to do good. Does that make sense?
Oh, absolutely. It makes sense.
So any suggestions on?
So I look at B and I see those are things you can never do.
Right.
Right, period.
Right.
And I look at A and I see, okay, if you're going to leave your dog outside and unattended, so you're not going to be around, you're just going to, tie him up somewhere. This is what you have to provide, right?
Right.
But we also, as I mentioned, we have to prove the person that owns the dog. And so for people who are homeless, and I will say I live close to Austin. And so I'm in Austin often, and I see the homeless camps, and I see lots of dogs. And I would say I don't think I've seen a dog tied up with a chain to like a pole in the middle of nowhere. Usually, whether I like it or not, what I'm seeing, the homeless folks are walking around with their dogs. Usually, honestly, without a leash. So, or they're sitting underneath 290 or 35 in the homeless camp, on the leash with their dogs, and there's always somebody around. So I don't see. I understand where you're coming from, but I don't see that this is going to be enforced upon homeless people. I think that it's going to end up being enforced on people who live in a home and who it's visible to the general public when they drive by or jog by. So having water. So I look at this, and potable water is drinkable water, but potable water is required under the penal code section and also the other section of 821 regarding when you can seize a dog. That's one of the requirements: food, water, and shelter. So shade from direct sunlight. I mean, that's sort of common sense in August. If you're providing shelter, what you need to provide. And then an area that allows a dog to avoid standing water. I mean, if your dog is, hanging out and cooling off in a puddle of water, then that's their choice. But we're talking about a shelter that's flush to the ground, that's sitting in standing water, and we've seen that. We've seen that in a lot of the cities that I've worked in, especially in the county. But I don't think, and this is just my own opinion based on my experience, I don't foresee law enforcement or ACOs, and certainly not prosecutors, because I can attest to that, targeting homeless people as far as this is concerned. I think I've seen officers ask them can you put your dog on a leash? Not, hey, please don't restrain your dog. And again, it's if the person's not there, so unattended and outside.
Okay.
And I'm also happy to provide resources for your district. If you can't find them anywhere, then I'm happy to work on that and help you with that in the future, any of y'all. So.
Thank you, Counselor. Any other questions concerning? Thank you, Ms.
Thank
Katz.
you.
I appreciate it.
Yes, sir.
And would you please, Ms. Katz, right quick, I need you to make sure you made it clear who you represented.
I am simply representing myself. I've outlined my experience, though.
Great.
Thank
you for making that clear. Is there anyone else who wishes to testify on for or against the committee substitute to HB 873? Or any resource witnesses? We have none, do we, left? So I see none, so therefore, the chair recognizes Chair Collier to close.
Thank you so much, Mr. Chairman. Members, Representative Crockett, let me just tell you this. It is not my intent, and I've never filed a bill that would disproportionately impact one sector of the community than others. If this is the section that you believe that would do that to the homeless, individuals who are homeless, then I'll work with you on language. However, I think you're missing the point, and I think a lot of you have missed the point. This bill only applies in those circumstances when someone leaves their dog outside, unattended, and on that leash. When you are talking about working in your yard, if your dog is out there on a leash, it's not unattended. You are attending the dog, you are there in the presence. You heard testimony from the animal control officer who said most people who are homeless have their dogs right there with them at all times. You even said that, Representative Crockett, that people don't even go into the shelter because they have their dog with them. So their dog is not unattended. So that provision of the bill would not even apply. And when you're talking about adequate shelter, you know what looks like adequate, what looks like a sturdy structure? A bridge. Someone is in a tent. That looks like adequate shelter. And I have not heard one animal control officer or law enforcement officer come up here and say that they would penalize somebody that is doing the best they can to care for their pet because of their living situation. In fact, they would even go above and beyond that and provide them the tools that they need. They would provide the education that they need. So I don't want you guys to miss the point that the animal, the dog, has to be outside, unattended, and on a leash that doesn't fit this requirement. Talking about someone, I wouldn't want anybody to just walk on my property either unless they have probable cause and there's a warrant. So absolutely. But if it's out there in the public and I can see it, then you're asking for trouble. So I completely agree with you, Rep. Kaysen. I don't want to invite somebody onto my property. I don't want to give them another reason to marginalize me. So that's not the intent of this bill. And if you feel like it is, I'm happy to work with you to address that. Again, they're not talking about seasoned animals. There's not even a provision in place right now that would allow them to address these concerns that everybody has raised. My constituents have asked for this. My constituents have called me for years, the years that this bill has been in the making. Have asked for this provision. Anyone who wants to humanely see, they want to see an animal treated humanely, they want to see this type of legislation passed because they care about what happens to these animals, okay? Those who are opposed to it have done a really good job of casting doubt into your mind, but I encourage you to work with your stakeholders, to work with me on this particular piece of legislation, and we'll figure it out. Because we're not trying to penalize people unnecessarily. We're just trying to do what's best, just like we're trying to do for black and brown people. We're trying to do what's best for these animals, okay? And I'm not trying to say that one is better than the other. I'm just saying that we need to do what's right in Texas. And this is what is right. Any questions?
Any questions?
Thank you. I'll work with you guys on this piece of legislation to make it amenable to you. And I ask for your favorable consideration once we get that figured out.
Thank you.
I close.
Chairman McCollier, thank you. If there's no objection, the chair withdraws the committee substitute for House Bill 873, and the bill will be left pending